Bismillahirrahmanirrahim. Assalamu alaikum. Welcome to the new era of this online teaching and learning. Today's topic is legal procedure. The procedure which is adopted before the court for the purpose of justice is called legal procedure. Procedure which is adopted before the court for the purpose of justice is called legal procedure. So first of all is the definition of law. Law is a code of social and moral behavior enacted by the parliament and codified into sections for ease of reference. So law is a code of social and moral behavior. It is social behavior and moral behavior. Laws are made by the parliament. Parliament means the National Assembly as well as the Senate. And this law is codified into sections for ease of reference as section 300 for the murder, 325 for the suicide. Another definition of law, it is the personal conduct enforced by the court. It is enforced by the court. So whether we like it or not, we will have to obey the law. It is our duty. International fact. Ignorance of law is no excuse. If a person don't know the law, he is not excused from on the basis that he don't know the law. To familiarize yourself, it is your duty to familiarize yourself with the law of the land. As if a person, he claim that he does not know whether a murder is to be committed or not, so I don't know the law, so I have done it. So the court will not accept this plea that he don't know the law. Knowing the law is your own duty. Types of law. Common law is based upon the traditions, and old law, it is an old law, it is not written. It is based upon the traditions and customs of the society. What are the norms of the society? As nobody in any era, nobody is allowed and will not be allowed to commit murders. So it is a common law which depends upon the traditions and customs of the society. Statute law. Statute law is a written law. This is a written law. This is a written law. It is made by the group of people which have given the authority to make the law, as National Assembly and Senate in Pakistan. They are authorized to frame the laws. So statute law are the written law. Common law is unwritten law. Statute law common law depends upon the traditions, customs of the society, while the statute law, it is made by the group of persons which authorized to make the law. So Senate and this National Assembly is authorized to make the law in Pakistan. Types of statute law. Statute law is divided into two types, ordinance and act. So ordinance is a temporary law. This temporary law is made by the President of Pakistan when the National Assembly or the Parliament is not in session and there is an emergency to frame the law. This ordinance is issued, and total duration for this ordinance, for this law, for this temporary law is 120 days. After 120 days, it should be reissued or it will be counted as null and void. Act is a law. It is a permanent law. In contrast to the ordinance, it is a permanent law. So act is passed by the parliament, by the National Assembly, by the Senate. Now, if the act is made, it is a permanent law. So it will remain effective until and unless cancelled by the same body as National Assembly and the Senate of the country. So difference between ordinance and act. Ordinance is a temporary law. Act is a permanent law. Ordinance is issued for certain period. Act is forever until and unless it is taken back by the it is cancelled by the parliament, or any amendment may be made in the act. So act is permanent law and the ordinance is a temporary law. Criminal law is to control the crimes in the society. Law relating to crimes. So criminal law effective to control the law and order situation of the country. It is for the law and to control the law and order situation of the country. So it comes in action when the society is affected. So criminal law relating to crimes. Then we come on to the civil law. Civil law deals with the private rights of the individuals or a group of individuals. Civil law which deals with the private rights of the individual or a private rights of the group of the individuals. As there is a family laws, these family laws, there the persons are affected. Society is not affected, as the case relating to family, case relating to possession of the children, and this divorce related cases, they are dealt under civil law. Same way, if a person get injury working in his factory, person get the injury, so he will go to the civil law for the award of compensation. Here the private rights of the individuals is disturbed. Islamic laws, these laws are made in the light of Quran and Sunnah. As there are hudud laws, there are Qisas and Diyat Act. These are the Islamic laws. Then the miscellaneous laws, as Muslim, as family laws, laws relating to family, laws relating to divorce, laws relating to possession of children. Then the labor laws, as laws relating to the persons working in the factories, etc., working as labor. Labor laws, these are the miscellaneous law. Now the difference between criminal law and civil law. Criminal law deals with the crime. This is criminal law comes into action for maintenance, law and order situation in the society, peace and order situation in the society. Civil law is for the personal redressing grievances between individuals or the party. For the personal rights of the individual, civil law comes into action. Criminal law deals with the offenses, state versus defendant. Civil law deals with the complaints, complainant versus defendant. In criminal laws, punishments are awarded as death sentence. As death sentence, here the punishments are awarded are the imprisonment of 1 year, 2 year, 3 year, 5 years, or life imprisonment. The punishments are awarded. In civil law, the compensations are granted, and these compensations are mostly in forms of money. These compensation in civil law are granted are usually in terms of money. Criminal law comes into action in cases of the murder, rape, abortion, drinking, treason. Treason means gaddari. And civil law comes into action where private rights of the individual is disturbed, as rents, tenancy act, कानून किरायादारी, insurance claim, recoveries. So laws, common law, as it unwritten law, depends based upon the traditions and morals and customs of the society. Statute law, this is a written law made by a group of persons authorized to make the law. Civil law is provide the remedy for the personal sufferings, and criminal law comes into action where a crime is committed. This is for to control the law and order situation of the country. Now the definition of law: any harm which has been defined and made punishable under the law. Any harm which has been defined means there is a definition of crime. There is a definition of crime, and also the punishment is prescribed. So there is a definition as well as the punishment is given. So it is called the crime. So any harm which has been defined. There is a definition of a crime as a murder. Murder has got the definitions. It is intentional killing with intention, with planning is the murder. And this is here there is the capital punishment is awarded, made punishable under law. So capital punishment is awarded. Capital punishment means punishment of death. So capital punishment is awarded for the murder cases. Criminal law is for the better law and order situation of the country, of the society. Here the society is affected. Civil law provides the remedy for the personal sufferings. It deals with the private rights of the individuals, where the individuals are suffered, where the parties are suffered, the civil law comes into action. Where the society is suffered, the criminal law comes into action. Presumption, principle of justice. So these are very important international rules, international laws. The justice system depends upon these three presumptions or principles of justice. Justice is insaf, adl. Everybody is innocent until and unless proved otherwise. Everybody, हर बंदा जो है उस वक्त तक वो मुजरिम नहीं है जब तक केस उसके खिलाफ अदालत में साबित नहीं हो जाता. Everybody is innocent until a case is proved against him before a court. So everybody, the first principle is everybody is innocent until and unless provide otherwise. Everybody is innocent until and unless a case is proved against him before a court of law. So this is first presumption. So everybody is innocent. A person against whom an allegation is made, a person against whom an allegation is made is accused person. Accused person means mulzam, जिसके खिलाफ इल्ज़ाम लगाया गया है. and if a case is proof against him, he will be culprit. Culprit means mujrim. A case has been proved before the court of law. So every person is innocent जब तक किसी के खिलाफ कोई केस अदालत में साबित नहीं हो जाता, उस वक्त तक वो बंदा जो है वो innocent ही रहेगा. Second is, it is the duty of the complainant to prove his case beyond doubt. ये जो इल्ज़ाम लगाने वाला है, ये उसकी ड्यूटी है कि वो अपना केस अदालत में शक व शुबे के बगैर साबित करे. ये डिफेंडेंट की ड्यूटी नहीं है कि ये मुल्ज़म की ड्यूटी नहीं है कि वो साबित करे कि मैं बेकसूर हूँ. ये जो इल्ज़ाम लगाने वाला है, ये उसकी ड्यूटी है कि वो अपने केस को शक व शुबे के बगैर जो है वो अदालत में साबित करे. So it is the duty of complainant to prove his case beyond doubt. So complainant person will prove his case before the court beyond any doubt. शक व शुबे से बाला वो अपना केस जो है ना वो अदालत में साबित करे. Third international principle of justice is all the doubts should be resolved in favor of accused. If any doubt arises during the hearing of the case, this benefit of doubt should be given to the accused. ये जो शक का फ़ायदा है ये मुल्ज़िम को मिलना चाहिए. All the doubts should be resolved in favor of accused. जितना भी ये जो है शक का फ़ायदा ये मुल्ज़िम को मिलना चाहिए. So 3 presumption principles of justice. Number 1, every person is innocent until and unless proved otherwise. जब तक किसी के खिलाफ केस अदालत में साबित ना हो उस वक्त तक वो इनोसेंट है, वो बेकसूर है. और ये जो है अदालत में केस साबित करना, ये इल्ज़ाम जो लगाने वाला है ये उसकी ड्यूटी है कि वो अपना केस अदालत में शक व शुबे से बाला जो है ना साबित करे. और अगर ट्रायल के दौरान कोई जो है शक का कोई मसला होता है, ट्रायल के दौरान कोई शक पैदा हो जाता है कि ये गड़बड़ हो गई है, तो उस जो शक का फ़ायदा है ये मुल्ज़िम को मिलना चाहिए. टाइप्स ऑफ कोर्ट्स in Pakistan, it is a university question. Define the courts and what are the types of courts in Pakistan. Court of trial, where the actual trial of the case is made. Court of trial means where the actual trial of the case is made. Where the actual hearing of the case is made is the court of trial. As in case of fights between individuals, these cases are dealt in the courts of magistrates. So magistrate court is the court of trial for the injuries. But in case of murder, a person is murdered, the court of trial is session court. Court of trial in case of murder, it is a session court. सो कोर्ट ऑफ ट्रायल जहाँ पे जो है वो समात होती है, पहले शुरू में उसको कहते हैं कोर्ट ऑफ ट्रायल. किसी केस की जो समात है वो किसी अदालत में शुरू हो जाती है, दैट इज़ द कोर्ट ऑफ ट्रायल वेयर एक्चुअल ट्रायल ऑफ द केस इज़ मेड. कोर्ट ऑफ अपील. नाउ व्हेन in a court of trial, a person, there may be two results. Person may be released or a punishment may be awarded. So against this decision of the court, a appeal may be lodged in the higher court. The appeal against the decision of the court may be lodged before the higher court, as in case of decisions made by the magistrate court. the appeal is made before the session court. So this is the court of appeal. Now, if in a case the court of trial in case of murder is the session court. Now, if the punishment is awarded to a culprit of the murder or the person is released, both the way appeal may be made before the high court. Appeal may be made for against the decision of the session judge before the judge of the high court. So court of appeal, court of trial, court of appeal. Court of trial, magistrate court and civil courts. These are the court of trial, magistrate court, civil courts. Court of appeal, where the appeal against the lower court is made. Here the session court, high court and supreme court is the court of appeal. High court, session court, high court and supreme court is the court of appeal. Supreme court in Urdu it is Adalat-e Uzma and high court is Adalat-e Aliya. Then the mixed type of third type court is the mixed type. Mixed type means it is a court of trial and also a court of appeal. Both the functions are performed by a single court. Is called the mixed court as a court of session court. In a session court, it is a court of trial of murder cases. It is a court of trial of murder cases, but also it is a court of appeal against the decisions of the civil courts, civil judges, civil courts, as well as the criminal courts as the court of magistrate. It is a court of trial for the magistrate courts and also the civil courts. So it has both the functions. Session courts have both the function. It is a court of trial as well as a court of appeal. Court of trial is for the murder cases where the death punishment is awarded, where the capital punishment is awarded. There is a session court. That the court of appeal is against the magistrate court. Appeal may be lodged against any decision of the magistrate court. This is the mixed type of court. So civil courts, magistrate courts and session courts for the punishment of death. These are the court of trial. Session court is also a court of appeal against the decision of the magistrate courts and the civil courts. So it is both a court of trial as well as a court of appeal. It is called the mixed court. The high court and the supreme court both are the court of appeal. These are not the court of trial. Criminal courts deals with the crimes where the society is affected to control the law and order situation of the country. मुल्क में अमन व अमान को बरकरार रखने के लिए जो है क्रिमिनल लॉ बनाया जाता है and for this is the criminal courts are there. So criminal courts, number one is the magistrate court. Magistrate court is a criminal court. Session court, it is also a criminal court. Session court is also a criminal court. Civil court is headed by the civil judge. So civil judge is a civil court where the cases relating to the private rights of the individual, they are taken as divorce case, labor case under the labor laws. These are dealt under civil cases where a person is affected or a party is affected. As a case in case of land grabbers, जो कब्ज़ा ग्रुप हैं, ये किसी के प्लाट पे कब्ज़ा कर लेते हैं, तो ये एक पार्टी इसमें सफ़र होती है, एक इंडिविजुअल सफ़र होता है, तो it will dealt in the civil court under the civil law. Then the routine courts. These courts are present as a matter of routine as magistrate court. These are the criminal courts, dealt with the crimes. Civil courts, these are the routine courts. Session court. Session court is present in a district. In every district under the district and session judge. One civil courts, the session court may also be present at the tehsil level. In some big tehsils, is additional session judge is there to head the session court, while this is mostly in every district this session court is there. So magistrate court, civil court, session courts, high court and supreme court, these are the routine courts. Then the special courts. Special court for a certain purpose is made as anti-terrorism court. These court as anti-terrorism court, these court deals only the cases where only relating to the terrorism. Then the labor courts. Labor courts, they dealt with the only the labor, particularly the person working in the factory. The matter relating to that, they will be challenged into the special court, labor court. Then the family courts. In the family court, the matters relating to family, as cases of divorce, cases of khula, the possession of children, are under the family courts. The routine court, magistrate court, then the civil courts, session court, high court and supreme court. Special courts as the court of speedy trials, then the anti-terrorism court, the courts of speedy trials, they are for the heinous crimes in the society, as rape against the small children in the past, particularly in the Kusur, there was a case. So for these special speedy trials or speedy trial court are made to dealt under the for the heinous crime occurred into a society. Special courts are made. So special courts, labor courts, family courts, anti-terrorism courts, speedy trial courts. Then again higher courts, Ala Adalatein, lower courts, Matahat Adalatein, higher courts, Ala Adalatein, lower courts, Matahat Adalatein. Higher courts, high court and supreme court are the higher courts, Ala Adalatein. High court and supreme court, they are the higher courts. Lower courts means Matahat Adalatein. So lower courts are session court, magistrate court and civil courts. These are the lower courts, Matahat Adalatein or Ala Adalatein. Ala Adalatein, high court, supreme court. Lower courts is the session courts, then the magistrate courts and the civil courts, higher courts and lower courts. These four types of courts are present in our country. Courts of Pakistan. Courts present in Pakistan, this is another university question. Describe the courts present in Pakistan. The highest court of justice in our country is the Supreme Court. In Urdu, it is called Adalat-e Uzma. So Adalat-e Uzma is the Supreme Court, is the highest court of our country. It is located in Islamabad, and some high court benches of the Supreme Court is present in the Lahore provincial headquarters, Quetta, Karachi and Peshawar. So Supreme Court, this is the highest court of the Pakistan. It is a court of appeal against the decision of the High Court, and also the main work of this Supreme Court is to interpret the law and constitution. Interpretation of law and constitution is the job of the Supreme Court. It is a court of appeal, and it also interpret the law as well as the constitution. Interpretation of law and constitution is the job of the Supreme Court. It also act as court of appeal against the decision of the High Court. It is headed by the Chief Justice Supreme Court. As you know, the age of this retirement of this judge of the Supreme Court is 65 years. Instead of 60 years, it is 65 years. Then the High Court, it is basically present in each province. High Court is under the Supreme Court, and it is present in every province, as Sindh High Court, Lahore High Court. It is not the Punjab High Court. Please keep it in mind. It is Lahore High Court. So High Court is headed by the Chief Justice High Court. It is also called a court of third instance. It is a court of third instance, High Court. The age of retirement for the judge of the High Court is 62 years. Session Court. Session Court is present in every district. Is headed by the district and session judge. There is in every district, this session court is headed by the district and session judge. So it is a court of second instance. Session court, under the session court, two types of courts are there: magistrate court, these, and civil courts. So court of first instance, civil courts, courts of magistrate, they are also called court of this is also called court of first instance. The magistrate courts, they are headed by the magistrates. You know the type of magistrate and their judicial powers. Judicial powers, अदालती इख्तियारात. अदालती इख्तियारात किस मजिस्ट्रेट की टाइप्स कौन कौन सी हैं और उनके पास कौन कौन से अदालती इख्तियारात है, वो किस हद तक जुर्माना कर सकते हैं, कौन कौन सी पनिशमेंट दे सकते हैं. दिस इज़ ए यूनिवर्सिटी क्वेश्चन as well as multiple MCQ may be asked from these. So magistrate are basically executive magistrates, two types, and judicial magistrates. Executive magistrates, they are involved in the management. So they have no judicial powers. In forensic medicine, they have no importance and they have no judicial powers. उनके पास अदालती इख्तियारात कोई नहीं है. Magistrate Section 30. The magistrate court and their judicial powers. This is a university question as well as a multiple MCQs. Magistrate Section 30. दफ़ा 30 का magistrate जो है, so any first class magistrate may be given the judicial powers of magistrate Section 30. So any first class magistrate may be given the judicial power of Section 30. So दफ़ा 30 का जो magistrate है, he can award, please keep it in mind, imprisonment is awarded. Imprisonment is awarded. So imprisonment up to 7 years. He can, magistrate Section 30 can award the imprisonment up to 7 years and fine no limit. 7 साल तक वो किसी को कैद कर सकता है और जो है फाइन की, जुर्माने की, इसकी कोई लिमिट नहीं है. Then first class magistrate, they can award imprisonment up to 3 years and can impose fine up to 15,000. can impose fine up to 15,000. Magistrate, second class magistrate darja 2, magistrate section 30, magistrate darja awal, magistrate darja 2, second class magistrate can award imprisonment up to 1 year, and fine, there is up fine, he can impose fine up to 5,000 rupees. Same way, third class magistrate class 3, magistrate darja soon, he can award imprisonment up to 1 month and fine up to 1,000 rupees. Maximum the judicial power of third class magistrate is he can award imprisonment up to 1 month and fine up to 1,000 rupees. There are special magistrate as honorary magistrate. Some respectable person may be given the designation of this honorary magistrate. He can only impose the fine. Legal procedure. The procedure adopted before the court for the purpose of justice. Now, what happens when a crime is committed? Legal procedure. What is done when a crime is committed? Society में कोई जुर्म हुआ है, कत्ल हो गया, तो उसका क्या legal procedure है? When a crime is committed, the police is informed. When a crime is committed, police is informed. Then police will register the FIR, first information report. Please, it is confused with the first investigation report. No, never and never ever. It is first information report. First information report. So the police will register the FIR. One word is used, FIR कट गई. FIR कट गई, ये उर्दू में बिल्कुल ठीक है, उर्दू में हो सकता है, but in English it is not the cutting of FIR, it is the registration of FIR. अगर आप इसको इंग्लिश में कहेंगे, आप इसको कटिंग नहीं कहेंगे, उर्दू में ये ठीक है, FIR कट गई, लेकिन इंग्लिश में it should be registration of FIR. When the FIR is registered, then the accused person is arrested. Accused person, the person against whom an allegation is made. This person is arrested. This person is arrested. And this person, accused person, is arrested by the police, and it is the legal duty of the police to present this accused person before the court of magistrate within 24 hours. 24 घंटे में हर गिरफ्तार बंदे को ये पुलिस की ड्यूटी है कि वो 24 घंटे के अंदर जो है वो मजिस्ट्रेट की अदालत में उसको पेश करे. 24 घंटे से ज़्यादा जो है पुलिस किसी बंदे को अपनी कस्टडी में नहीं रख सकती, उसको जो है मजिस्ट्रेट को 24 घंटे में पेश करना ज़रूरी है. So, presented, the accused is presented by the police before the court of magistrate for award of remand. Remand means permission of physical custody. ये इतने दिन के रिमांड पर है. So during this period of remand may be for 1 day and may be maximum for 14 days. 14 दिन तक के लिए, एक दिन से 14 दिन के लिए रिमांड इशू किया जा सकता है. It depends upon the magistrate court. वो जहाँ पे सेटिस्फाई हो जाए कि नहीं, एक दिन का रिमांड ज़रूरी है, ज़्यादा ज़रूरी नहीं है, ये कह दे 14 दिन का रिमांड ज़रूरी है, उस जो एक्सपायरी, रिमांड ऑफ एक्सपायरी के बाद उसको फिर कोर्ट ऑफ मजिस्ट्रेट में जो है ना वो पेश करते हैं. वो कहते हैं जी कि रिमांड को एक्सटेंड कर दे. द मजिस्ट्रेट मे एक्सटेंड द रिमांड फॉर another 14 days. It is a judicial powers that he can extend his remand for another 14 days. Then during this remand, during this physical custody, when the person is in the police station, so for the investigation is made for during this remand period, and usually torture is committed against the accused person for confession of a crime. So investigation of the case is made by the police. This investigation of the case is made by the police, and during this investigation the torture cases there may be there. The torture is used, inhuman torture is used for confession of the crime. So after this investigation, after the expiry of the remand, the challan is completed. The papers are completed. This person has committed so and so crimes, जैसे पिस्टल से रिकवर हो गई, जो है वो वेपन ऑफ मर्डर रिकवर हो गया, या और जो रिकवरी है वो होगी, पूरे पुलिस पेपर जो है वो बना के, तो इसको जो केस इज़ प्रेजेंटेड बिफोर द कोर्ट. नाउ दिस केस इज़ प्रेजेंटेड बिफोर द कोर्ट. कोर्ट जो है उसमें केस का ट्रायल होता है. दोनों तरफ से जो हैं वो जो ये जो हैं गवाह वो पेश होते हैं और जो है ट्रायल शुरू हो जाता है. ट्रायल के एंड के ऊपर द जज विल, द कोर्ट, जज एंड कोर्ट इज़ द सेम थिंग. द कोर्ट विल डिसाइड whether to award punishment or to release a person. So the judge will declare its decision whether a punishment is required or release is awarded. So against both, please keep it in mind, the person may go to the higher court for appeal in case of punishment and also in case of release. In both cases, the appeal may be lodged before the higher court. So this is the legal procedure, the procedure adopted before the court for purpose of justice. When a crime is committed, police is informed, police register the FIR, then police will arrest the accused person. It is the duty of the police to present this accused person before the court of magistrate within 24 hours for award of remand, for permission of physical custody for the purpose of investigation. Then the investigation is made, challan is, papers are completed, case is presented before the court, then the trial of the case is made, then the punishment or release is awarded by the court, then appeal may be lodged or may not be lodged before the higher court. This is the legal procedure. This is the setup of a court. See here the accused person, when you enter a court, बिल्कुल सामने जो है वो जज होगा बैठा हुआ, और आपके राइट साइड के ऊपर मुलज़म की जगह है और आपके लेफ़्ट साइड के ऊपर जो है ये विटनेस है. जो डॉक्टर है वो एज ए विटनेस पेश होता है. ही इज़ ए विटनेस, सो ही विल स्टैंड ऑन द लेफ्ट साइड, ऑन दिस साइड. सो डॉक्टर जो है वो लेफ्ट साइड पे होगा, जो अक्यूज्ड पर्सन है मुलज़म जो है वो राइट साइड पे होगा. इधर जो है डिफेंस वाले वकाला होंगे, इधर वो प्रोसिक्यूशन वाले वकाला होंगे. सेम वे judge on the, when you enter from this entrance, in front is judge, on the left side is the typist, on the right side is the reader. Here the witness, prosecution, here the defense means the accused person. Then here the law officers, the lawyers. Then the waiting area, public seat is there. This is the record keeper room. Inquest. Inquest is legal or judicial inquiry in cases of sudden and suspicious deaths. It is a legal or judicial inquiry in cases of sudden and suspicious deaths. It is a legal inquiry in cases of sudden and suspicious. Sudden death. Sudden death means the person was already before the death. He was suffering from not any disease where a sudden death may occur. So he is apparently alright, having no disease at all, but suddenly he died. There is sudden and suspicious where the शक लगता है कि ये कहीं फाउल प्ले किया गया है, इसको मारा गया है, उसमें जो जुडिशियल और जो लीगल इंक्वायरी है उसको कहते हैं इंक्वेस्ट. सो इट इज़ द इंक्वेस्ट, इट इज़ द लीगल और जुडिशियल इंक्वायरी in cases of sudden and suspicious deaths. The deaths in the mental hospital, deaths in the police custody, all the inquest is made. So inquest is police inquest, may be police inquest or magistrate inquest. So police inquest here in Pakistan, usually a police inquest is there in sudden and suspicious death. So the police officer of minimum rank to conduct the inquest is the ASI, Assistant Sub Inspector, is the minimum rank which can inquest, which can make an inquiry in cases of sudden and suspicious death. ASI, असिस्टेंट सब इंस्पेक्टर. उससे नीचे के रैंक वाला बंदा जो है ये इंक्वेस्ट में नहीं आ सकता. सो द यूजुअली द ASI, they are given the task to make an inquiry into the sudden and suspicious death. Same way a magistrate may be given a duty to conduct the inquiry into sudden and suspicious deaths. Coroner inquest, this is a university question. This coroner system of investigation is present in the England and in Bombay. Now it is the Mumbai city of India. Two places where this coroner system is present. Number one is all the England, and in Mumbai city of India this coroner system is present. Coroner is a person appointed to hold inquiry in cases of sudden and suspicious death. Coroner is a person, he is appointed to hold inquiry into sudden and suspicious deaths. Coroner inquest, he is first class magistrate or a lawyer. Coroner is a person appointed by the government to conduct the inquiry into sudden and suspicious deaths. So the coroner is either first class magistrate or any lawyer may be appointed as coroner, called the coroner's court. Coroner की अदालत जी. Powers of coroner. The coroner person have the following power. This coroner inquest and powers of the coroner is the university question. Power of the coroner. He can order a post-mortem examination. He can order a post-mortem examination. Now, in case of Pakistan, it is the police, it is the ASI. He will decide whether a post-mortem is to be conducted or not. It is not the doctors who will decide. It is the policeman. It is an ASI. He will decide whether a post-mortem examination is required or not. In case of coroner inquest in England, in Mumbai city of India, it is the coroner who will decide whether a post-mortem examination is required or not. Second power, he can summon the witness. Summon, it is a written and signed order issued by the court for the presence of a person, for presence of a witness on certain time and date before the court. So summon is a written order. इसको कहते हैं अदालती बुलावा. अदालत की तरफ से बुलावा आया है. तो summon is the written and signed order issued by the court for appearance of a person as a witness on certain date and time before the court is the summon. अदालती बुलावा. Warrant, no. Third power of the coroner is he can issue the warrant of arrest of an accused person. He can issue the warrant of arrest of an accused person. So it is his power that if a person, if a witness, after noting down the summon, after duly receiving the summon, he fails to appear before the court without any lawful excuse, किसी भी कानूनी हिच के बगैर जो है अगर कोई बंदा सम्मन रिसीव करके अगर वो अदालत नहीं जाता तो वो सेकंड सम्मन का जो सेकंड पार्ट है वो वारंट है. सो देन द वारंट मे बी issued by the coroner court. So he can issue warrant of arrest of an accused. It is his power. Then number 4, he can order an exhumation. Again, it is the coroner who will decide whether an exhumation should be done or not, whether it will remain fruitful or not. It is decided by the this coroner. In Pakistan, it is decided by the police. The medical opinion is also taken from the district health officer and medical superintendent DHQ hospital. The opinion is also taken, but it is the police who will decide whether an exhumation, disinterment of the dead body after burial, exhumation is needed or not. Next is the coroner can appoint the deputy coroner. It is his power. He may appoint the deputy coroner, the person of his choice, depending upon the qualification and experience prescribed there. Now this is the end of the first lecture. Thank you very much. Please give your feedback and then at the end I will give the